Glossary, Chapter 1, Unit 1. Act,
Hành vi,
administer,
quản lý, thi hành công lý,
adopt,
thông qua,
aspect,
khía cạnh,
authority,
thẩm quyền, quyền hạn, cơ quan,
behavior,
cách xử sự,
bind,
ràng buộc, có hiệu lực bắt buộc,
civil law,
luật dân sự,
circumstance,
hoàn cảnh, tình huống,
community,
cộng đồng,
compliance,
tuân thủ pháp luật,
commit,
phạm tội,
conveyancing,
sự chuyển nhượng sang tên tài sản,
coerce,
cưỡng chế,
content,
bằng lòng, toại nguyện,
criminal law,
luật hình sự,
criminology,
tội phạm học,
criterial,
chuẩn mực, tiêu chuẩn,
conflict,
đối lập, bất đồng, xung đột,
distinguish,
làm nổi bật, phân biệt rõ,
dissertation,
luận án, luận văn,
enforce,
buộc mọi người phải tuân theo, có hiệu lực,
establish,
thành lập,
family law,
luật hôn nhân và gia đình,
gunman,
gangster,
indispensable,
không thể miễn trừ,
individual,
cá nhân,
issue,
ban hành,
intend,
dự định,
judicial,
thuộc về pháp luật,
jurisdiction,
pháp quyền, quyền thực thi pháp luật,
jurisprudence,
luật học,
law state,
nhà nước pháp quyền,
legalize,
thể chế hóa,
legislate,
lập pháp, làm luật,
legal system,
hệ thống pháp luật,
moral norm,
quy phạm đạo đức,
an offender,
người phạm tội, người có tội,
option,
sự lựa chọn,
parliament,
quốc hội, nghị viện,
pedigree,
cội nguồn, điểm xuất phát,
perspective,
viễn cảnh,
prosecute,
khởi tố, truy tố, kiện,
proceed,
tiến hành, khởi tố,
property,
tài sản,
represent,
trình bày, miêu tả,
reserve,
duy trì,
rule of law,
pháp trị, pháp quyền,
set,
hệ thống, sự tổng hợp,
undergraduate,
sinh viên chưa tốt nghiệp,
valid,
có hiệu lực,
violation.
sự vi phạm.
Audio transcripts, Chapter 1, Unit 1, Listening 1. There are many ways in which the law can be classified. Here we shall limit our discussion to the difference between criminal and civil law, and substantive and procedural law. Criminal and civil law. A simple distinction between the criminal and civil law is that the latter, civil law, regulates the relationships between individuals or bodies, and the former, criminal law, regulates the legal relationship between the state and individual people and bodies. The first practical difference is seen in the parties to the legal action. A civil case will involve two or more individual people or bodies, whilst the parties to a criminal case will be the state and an individual person or body. Later, you will learn how this difference is reflected in the terminology and procedure of the law. A further point to make is that although the division between civil and criminal law is very clear, there are many actions which will constitute a criminal offense and a civil wrong.
Listening to Law. The law course at Cambridge is intended to give a thorough grounding in the principles of law, viewed from an academic rather than a vocational perspective. Undergraduates reading law for 3 years take part IA of the tripos at the end of the first year. This comprises 4 papers: criminal law, constitutional law, the law of tort, and Roman law. In the second year, 5 subjects are studied for Part IB of the law tripos, which is taken at the end of the year. The range of subjects on offer is wide, from family law to international law, though in practice most undergraduates take contract and land law as 2 of their papers. In the third year, 5 subjects are studied for Part 2 of the tripos. The range of options is even wider than in Part IB. According to preference, an undergraduate may develop his or her interest in property law, including trust and conveyancing law, commercial law, public law, including administrative law and EEC law, or in more academic and sociological aspects of law, such as jurisprudence, legal history, labor law, and criminology. Candidates may also participate in the seminar course, submitting a dissertation in one place of 1.
Introducing Unit 2. To be set down.
Được ban hành, được đưa ra.
Create.
Tạo thành, sáng tạo.
Contradict.
Phủ nhận, cãi lại.
Criticize.
Phê bình.
Custom.
Tục lệ, phong tục.
Customary law.
Tập quán pháp.
Determine.
Quyết định, xác định.
Engage.
Dàn xếp để tuyển dụng, chiếm hay thu hút.
Exist.
Tồn tại, xảy ra.
Execute.
Thi hành, chấp hành.
Exercise.
Thực thi.
Express.
Biểu lộ, diễn đạt.
Give rise.
Làm phát sinh.
Hand down.
Truyền lại.
Imagine.
Tưởng tượng, hình dung.
Legislation.
Xây dựng pháp luật, sự lập pháp.
Protect.
Bảo vệ, bảo hộ.
Perform.
Thi hành, thực hiện.
Practice.
Thực hành.
Precedent.
Án lệ.
Prevail.
Chiếm ưu thế.
Public law.
Luật công.
Private law.
Luật tư.
Recite.
Kể lại.
Recognize.
Nhận ra, chấp nhận, thừa nhận.
Refute.
Bác bỏ.
Rest on.
Dựa vào.
Satisfy.
Đáp ứng.
Statute law.
Pháp luật thành văn.
Scrutinize.
Nhìn nhận hoặc xem xét cẩn thận và tỉ mỉ.
Struggle.
Đấu tranh.
Succeed.
Thành công.
Try.
Xét xử.
Uphold.
Duy trì.
Violate.
Vi phạm.
Unit 2. Listening 1. Passing an act. All acts must be submitted to both houses of Parliament in the draft form of a bill. The legislative process involves 3 readings in both houses. At the first reading, the title is read to the Members of Parliament, MPs. At the second reading, MPs debate proposals. Then a standing committee will scrutinize the provisions in the bill and may amend it to ensure that it enshrines the principles debated and approved at the second reading. At the third reading, the bill is re-presented. The bill then goes through readings in the upper house. The actual drafting of the legislation is undertaken by Parliamentary Council. Finally, a bill must receive royal assent from the monarch before it becomes law on a specified date. In fact, this stage has been reduced to a formal reading of the short title of an act in both Houses of Parliament and is now formality. Government bills are introduced by the government. Private members' bills are proposed by MPs. Both methods may result in public acts that govern the general public. Private acts affect particular individuals or institutions. Listening 2.
So, how are things going? Are you having trouble with the lectures?
Well, I did at the beginning. I had to get used to the accents. It was very frustrating. People here speak very quickly, which makes it harder to understand. But now it's much easier. I can understand almost everything.
I wish I could say the same. Sometimes I only understand half of the lecture. I have the trouble writing too. That's more difficult for me than understanding what people say. But I can normally find someone to look at my work and make corrections.
Yes, I think writing's the hardest thing to do in English. But we did do a lot of writing exercises in my legal English course at university. That definitely helped.
Writing exercises? We didn't have any writing practice in English course we took. We learned a lot of terminology, a lot about common law systems, how things work in America and in the UK.
Really? Our course was more practical. We worked on the language skills that lawyers need, writing, reading, even doing legal research in English. And we had to write lots of different things, texts that lawyers really have to write, like letters to clients, memos, that kind of thing.
We had to give presentations about different institutions. I gave one about the U.S. Supreme Court. We didn't really work on speaking or research skills, though. It was more important to present the terminology. I described how the U.S. Supreme Court is set up and how it works.
We gave presentations too, but our presentations were on more practical topics. We did need to learn some terminology for those. We had to present case briefs or talk about our own legal systems.
We didn't talk about the laws of our country at all, only about the USA or the UK.
We compared the laws of different countries quite a bit. We read a lot about other legal systems, other countries' laws, but we mainly practiced speaking about our own legal system and talked about how things work in our country. That was definitely the most useful thing we did.
It sounds like it was better than mine.
I don't know if it was better, but it was certainly more language-based and more skills-based.
Well, it certainly looks like you're better prepared than I am.
Unit 3. Arbiter.
Người có quyền quyết định làm.
Ambiguous.
Mơ hồ, khó hiểu.
Accessibility.
Sử dụng được.
Assert.
Khẳng định.
Bill.
Dự luật.
Contradictory.
Mâu thuẫn, trái ngược.
Comprehensibility.
Có thể hiểu được đầy đủ.
Debate.
Thảo luận, tranh luận.
Democracy.
Chế độ dân chủ.
Enshrine.
Lưu giữ.
Gigantic.
Cách xù.
Incorporate.
Kết hợp.
Lawmaker.
Ngành lập pháp, người làm luật.
Liberty.
Quyền tự do.
Medieval.
Thuộc về thời Trung Cổ.
Precedent.
Án lệ.
Requirement.
Yêu cầu, đòi hỏi.
Submit.
Đệ trình.
Unit 3. Listening 1. Law Reports. The development and application of the common law system pivots upon the existence of the comprehensive system of reporting cases. The law reports, published annually by the Council of Law Reporting, are perhaps the most authoritative and frequently cited set of reports. differing from other series of law reports, such as Butterworth's All England Law Reports, All ER, or specialist reports like Lloyd's Law Reports, in that they contain summaries of counsel's arguments and are revised by the judge sitting in each respective case before publication. Cases aren't always reported in the year that they are decided, so a case citation will refer to the volume and the year in which the case was published. For example, Mea versus Roberts, 1978, 1 All ER 97. Developments in electronic databases have increased public access to recent cases.
Listening to Common Law in the U.S. Most of the British common law, as it existed at the time of the American Revolution, became the foundation of a distinctly American system of law. Common law has varied from state to state, but only one state, Louisiana, differs significantly from the rest, basing its system on the French civil law model. In each state, the highest appellate court, usually the state supreme courts, is the ultimate arbiter of the common law, subject to alterations by legislative action. The U.S. Supreme Court is the ultimate arbiter of all federal law and of the U.S. Constitution, which is superior to all other laws. As in Great Britain, statutory law has largely supplanted common law in state and federal systems, although common law is still influential. The order of authority of law in the U.S. is the Constitution, treaties with foreign powers and acts of Congress, state constitutions, state statutory law, and finally, the common law. Chapter 2, Unit 1. Court of Appeals.
Tòa phúc thẩm,
District Court.
tòa án huyện,
Criminal Court.
tòa hình sự,
Federal Court.
tòa liên bang,
Court of First Instance.
tòa sơ thẩm,
Civil Court.
tòa dân sự,
Circuit Court.
tòa lưu động,
Family Court.
tòa gia đình,
Military Court.
tòa quân sự,
Industrial Court.
tòa lao động,
Juvenile Court.
tòa án vị thành niên,
Hierarchy of Courts.
hệ thống tòa án,
Judiciary.
hệ thống tòa án,
Institution.
cơ quan,
Interpret.
giải thích,
Mechanism.
cơ chế,
Dispute.
tranh chấp,
Doctrine.
học thuyết,
Legislature.
cơ quan lập pháp,
Supreme Court.
tòa tối cao,
Precedent.
tiền lệ,
Annul.
bãi bỏ,
Incompatible.
không phù hợp,
Critical.
quan trọng,
Implementation.
thực hiện,
Disengage.
bãi bỏ,
Adjudication.
xét xử,
Tribunals.
tòa hòa giải,
Arbitration.
trọng tài,
Litigation.
sự kiện tụng,
Solicitor.
luật sư tư vấn,
Equivalent.
tương đương,
Appellate.
phúc thẩm,
Distinction.
khác biệt,
Plaintiff.
nguyên đơn,
Defendant.
bị đơn,
Appeal.
kháng cáo,
Reconsideration.
sự xem xét lại,
Appellant.
kháng cáo,
Adjudicate.
phán quyết,
Matrimonial.
thuộc về hôn nhân,
Guardianship.
giám hộ,
Adoption.
sự thông qua,
Affiliation.
sự liên kết,
leapfrogging,
nhảy cóc,
wrongdoer,
người vi phạm,
consequence,
hậu quả,
convict,
kết án,
indictable,
buộc tội,
prosecute,
truy tố,
arson,
tội ý gây hỏa hoạn,
manslaughter,
tội ngộ sát,
verdict,
phán quyết của thẩm phán,
affidavit,
bản lời khai,
pleading,
biện hộ.
writ.
Chapter 2, Unit 1, Listening 1. Good morning, everyone. In today's lecture, we are going to look at the way the court system in England and Wales is organized. There are various ways of classifying courts. Thus, it is possible to classify courts according to their functions and jurisdiction. Courts are generally classified into the criminal and the civil systems. This classification is not, however, valid since although certain courts do exercise purely civil or criminal jurisdiction, most English courts hear both civil and criminal cases. The highest court in the land is known as the Supreme Court. It deals with both civil and criminal cases. The Supreme Court is also called the House of Lords, which sat as a court. Below the House of Lords is the Court of Appeal. There are two separate divisions, civil and criminal. Below the Court of Appeal is the High Court. The High Court is the highest court of first instance. There are three separate divisions, the Queen's Bench, the Chancery, and the Family Division on the civil side, while on the criminal side there is only one section, the Queen's Bench. Below the High Court on the civil side is the County Court, and on the criminal side, the Crown Court. The County Court deals with relatively straightforward cases, such as divorces and trespass to property. The Crown Court deals with serious criminal cases and appeals from Magistrates' Court. The Magistrates' Court is the lowest level court and has jurisdiction over a locality. It is presided over by lay magistrates or justices of the peace, or by legally trained judge. There are no juries sitting in the magistrates' courts. The Court of Justice of the European Communities was set up under the Treaty of Rome of 1957, by which the European Community was established. The court can overrule all other courts on matters of community law. Listening 2. Listening to the conversation between two friends about the Vietnamese court systems and fill in the blanks.
Hi, Mary. Have you been waiting very long?
Hi, Lauren. Not really. I've just come in.
How is your study at Hanoi Law University at the moment?
It's okay. By the way, could you tell me a little bit about the Court of Vietnam? It's a subject I would like to specialize in.
It's a pleasure. What do you want to know?
First of all, for a general picture of the Judiciary, how is the courts organized in Vietnam?
Under Article 130, the 1992 Constitution, the judges are independent during the trials and subject only to law. The People's Courts are organized in 3 levels: the central level, the provincial level, and the district level.
Which court has the jurisdiction at the central level?
The Supreme People's Court is the highest adjudicating body at the level. It composes of the Council of Judges, the Central Military Court, the Criminal Court, Civil Court, Economic Court, Labor Court, Administrative Court, and Appellate Courts of the Supreme People's Court. In case of necessity, the National Assembly Standing Committee shall decide to set up other specialized courts.
I see. What is the function of the Supreme People's Court?
The Supreme People's Court has powers to guide courts to uniformly apply laws, to supervise the trials by tribunals at different levels, to review trials of cases with judgments, and to submit bills or draft ordinances to the National Assembly.
And at the provincial level, which court has the adjudicating authority?
At this level, we have people's courts of provinces and cities directly under the central power.
How interesting. What about the last level?
These courts are called people's courts of districts, prefectures, towns, and cities, other provincial powers, which have the power of courts of first instance.
Thanks a lot for your information. It's really helpful. Now it's clear to me the organization of the courts in Vietnam.
If you want to know more, feel free to ask me anyway.
I will. Thanks. Goodbye.
Bye. Unit 2. Advocacy.
Sự bào chữa.
Advice.
Lời khuyên, sự tư vấn.
Advise.
Khuyên, tư vấn.
Advisor.
Người tư vấn.
Ambiguity.
Sự mập mờ.
Areas of law.
Các lĩnh vực của luật.
Argue.
Tranh cãi, tranh luận.
Argument.
Sự tranh cãi, sự tranh luận.
Barrister.
Luật sư tranh tụng.
Bar vocational course.
Khóa đào tạo nghề luật sư tranh tụng.
Brief.
Bản tóm tắt, tóm tắt.
Chamber.
Phòng, đoàn luật sư tranh tụng.
Criticism.
Sự phê phán, phê bình.
Concerned.
Có liên quan.
Conversion course.
Khóa học chuyển đổi.
Conveyancing.
Chuyển quyền sở hữu tài sản.
Court form.
Mẫu đơn của tòa án.
Court pleadings.
Lời bào chữa tại tòa.
Draft.
Soạn thảo.
Degree.
Bằng cấp.
Draw up.
Soạn thảo.
Expert.
Chuyên gia.
Firm.
Công ty.
File.
Nộp đơn, nộp hồ sơ.
Fill out.
Điền vào giấy tờ.
Fusion.
Hợp nhất.
In writing.
Bằng văn bản.
Issue.
Vấn đề.
Out of court.
Ngoài tòa án.
Partnership.
Sự cộng tác, công ty hợp danh.
Preparatory.
Chuẩn bị.
Primarily.
Trước tiên, chủ yếu.
Profession.
Nghề nghiệp.
Provide.
Cung cấp.
Pupil master.
Luật sư hướng dẫn.
Pupilages.
Khóa tập sự luật sư tranh tụng.
Representation.
Sự đại diện.
Right of audience.
Quyền bào chữa.
Secondment.
Sự biệt phái.
Senior barrister.
Luật sư tranh tụng cấp cao.
Scrivener.
Công chứng viên.
Shadow.
Đi theo để học nghề.
Solicitor.
Luật sư tư vấn.
Tenancy.
Chức danh thành viên đoàn luật sư.
Traineeship.
Khóa tập sự luật sư tư vấn.
Trainee.
Người tập sự luật sư tư vấn.
Qualification.
Trình độ. Bằng cấp.
Unit 2. Listening 1. Solicitors. A. Legal practitioners. Lawyers in the United Kingdom jurisdictions generally practice as solicitors in private firms, as legal advisors in corporations, government departments, and advice agencies, or as barristers, see Unit 10. They can each do advocacy, draft legal documents, and give written advice, but solicitors, unlike barristers, cannot appear in every court. Traditionally, solicitors undertake work such as conveyancing and drawing up contracts and wills. Barristers spend more time in court and have a right of audience in the higher courts. Unlike solicitors, barristers cannot usually be employed directly by clients but are instructed by solicitors. Solicitors normally form partnerships with other solicitors and work in offices with support staff. The qualification and practice of solicitors are regulated by the Law Society.
B. Training. Sammy, a 25-year-old graduate, is talking about his experience as a trainee.
My first degree was in engineering at Manchester University. Then I did 2 one-year law courses. The first led to the Common Professional Examination, or CPE. The second was the Legal Practice course. I had a vacation placement at Applewood Branston, who offered me a 2-year traineeship. They have a 6-seat system, which is quite common. Trainees spend time attached to different law departments, which suits me as I get a basic grounding in the main departments of the firm, helping me find which area of the law I'd like to specialize in. I can work in 4 or more different areas of law for 4 months at a time and then decide on a specialism later in the training contract. In my 3rd seat in corporate finance, I've learned a lot from being on secondment with a client and got excellent backup from my seat supervisor. That is, supervising partner. It was good to put the professional skills training into practice straight away. C. A partner in a law firm, Helen, from Monaco, is an avocat admitted to the Paris Bar, the professional association for lawyers. She graduated with a Bachelor of Law, LLB, in Paris and obtained a master's degree, LLM, in European Law from University College, London. She is a graduate of the Paris Institute d'Etudes Politiques.
I joined Applewood Branston 2 years ago and was promoted to partner in the corporate and banking team in Paris. Before that, I worked for 12 years for other leading international law firms. I've got extensive experience of privatizations, mergers and acquisitions, and I advise investment banks and corporates.
Listening to the American Bar Association. The American Bar Association is the national organization for the legal profession in the United States. Its members principally are practicing lawyers, judges, court administrators, law teachers, public service lawyers, lawyers whose current positions do not directly involve the practice of law, such as business executives and government officials, and law students. In 2002, with more than 400,000 members, including more than 350,000 attorneys, the ABA is the world's largest voluntary professional association. It has long served a dual role as advocate for the profession and for the public, and the membership includes approximately half of all lawyers practicing in the United States. The ABA provides law school accreditation, continuing legal education, information about the law, programs to assist lawyers and judges in their work, and initiatives to improve the legal system for the public. Although the actual power to admit attorneys and to discipline lawyers rests with the individual states and other jurisdictions in the United States, the ABA is a major force in establishing the ethical guidelines for the provision through promulgating the ABA model rules for professional conduct. The ABA also is a very influential voice in matters related to the law and the legal profession before Congress and the executive branch in Washington, D.C. Admission to the bar in the United States is governed by independent rules and regulations established in each of the 50 states, the District of Columbia, the Commonwealth of Puerto Rico, and other U.S. jurisdictions. Over half of these jurisdictions require that one must have graduated from an ABA-approved law school in order to be eligible for admission to practice law in the jurisdiction. Of those jurisdictions that permit graduates of non-ABA-approved law schools to sit for the bar, most limit that privilege to graduates of non-ABA-approved law schools located in their specific jurisdiction. A typical state bar examination lasts 2 or 3 days and consists of at least 2 major parts. An objective examination, the multi-state bar examination created by the National Conference of Bar Examiners, NCBE, which tests basic knowledge of fundamental areas such as contracts, property, torts, procedure and constitutional law, and an essay examination covering topics chosen by the individual jurisdiction. An increasing number of jurisdictions use the multi-state essay examination prepared by the NCBE rather than drafting their own essay examinations. Over half of jurisdictions also now use the Multi-State Performance Test, MPT, also produced by NCBE, as a proportion of their essay examination. The MPT test particular lawyering skills by providing the examinee with a factual setting and the legal principles applicable to the situation, and then asks the examinee to produce a legal document, such as a will, contract, or pleading. All jurisdictions also conduct a character and fitness for investigation of all persons who seek admission to practice law. Most jurisdictions permit an attorney who has been admitted to practice for a specified number of years, commonly 5, and is in good standing in the jurisdiction in which he or she is admitted, to be admitted by motion without taking a new bar examination. Some jurisdictions, however, require that even an attorney being admitted on motion pass an attorney's examination, which usually focuses on procedural rules and ethical requirements. A few states, such as Florida and California, do not permit even experienced attorneys to be admitted without taking the bar examination for their state.
Listening 3. A legal secretary. An assistant solicitor is instructing Marie Lapotaire, the commercial department's legal secretary.
I've just sent you some sound files with the minutes from yesterday's meeting. Is there any way you can type those up before anything else? I know you've got a substantial amount of work at the moment.
No problem. Do you want me to circulate them by email as soon as I've finished? Get a hard copy and put it on the file?
Please. I'm going to be running between meetings for a large part of the day, but if I get a minute, I'll have a quick look at the hard copy and mark it up with any changes. Don't wait for me to do that before getting the draft out. There are action points that the paralegals need to be getting on with.
Fine. I'll copy everyone in. Anything else? I've put all the documentation for Project Angel on your desk. I don't know if it's ready to go out yet.
I saw that. Thanks. No, I need to make sure that the client is happy with the latest clauses the funder wants. Also, I think they may have negotiated more concessions, so I'll have to get back to you on those.
Okay. By the way, I think your out of office message is still on, although the date's wrong. Don't worry, I'll change it. Your calls are still coming through to my phone, so I'll carry on taking messages.
Unit 3. Accused.
Kẻ bị buộc tội.
Adoption.
Việc nhận con nuôi.
Affiliation.
Việc xác nhận tư cách làm bố.
Appoint.
Bổ nhiệm.
Biased.
Có thành kiến.
Bench.
Quan tòa, nơi xét xử tại tòa.
Clerk.
Thư ký tòa.
Civil fraud.
Lừa đảo dân sự.
Challenged.
Bị kiện, bị phản đối, bị nghi ngờ.
Criminal.
Kẻ phạm tội.
Commit.
Thực hiện.
Defense.
Luật sư bên bị.
Electoral register.
Danh sách cử tri.
Eligible.
Đủ tư cách.
False imprisonment.
Giam giữ trái phép.
First degree murder.
Giết người cấp độ 1.
Malicious prosecution.
Cố tình khởi tố.
Maintenance.
Tiền cấp dưỡng.
Misconduct.
Hành vi sai.
Municipal ordinance.
Quy định của thành phố.
Lay.
Không chuyên.
Imprisonment.
Việc giam giữ.
Inquest.
Điều tra.
Interim injunction.
Lệnh tạm thời.
Profile.
Tiểu sử sơ lược.
Juror.
Bồi thẩm viên.
Juvenile.
Thanh thiếu niên, vị thành niên.
Jury service.
Sự phục vụ của bồi thẩm đoàn.
Jury trial.
Xét xử bằng bồi thẩm đoàn.
Plea bargain.
Thương lượng bằng lời khai của bị đơn.
Political.
Thuộc về chính trị.
Recorder.
Thẩm phán kiêm nhiệm.
Second degree murder.
Giết người cấp độ 2.
Stipendiary magistrate.
Thẩm phán tòa sơ thẩm.
Suspended sentence.
Án treo.
Verdict.
Phán quyết của bồi thẩm đoàn.
Violence.
Bạo lực.
Waive.
Từ bỏ.
Unit 3, Listening 1, Judicial Member. Part 1, Magistrates. Magistrates usually work in magistrates' courts. These courts hear cases of petty crime, adoption, affiliation, maintenance and violence in the home. The court can commit someone for trial or for sentence in a crown court. There are two main types of magistrates: stipendiary magistrates, qualified lawyers who usually sit alone; lay magistrates, unqualified, who sit as a bench of 3 and can only sit if there is a justice's clerk present to advise them.
Part 2. Judges. In England, judges are appointed by the Lord Chancellor. The minimum requirement is that one should be a barrister or solicitor of 10 years' standing. The majority of judges are barristers, but they cannot practice as barristers. Recorders are practicing barristers who act as judges on a part-time basis. The appointment of judges is not a political appointment, and judges remain in office unless they are found guilty of gross misconduct. Judges cannot be members of Parliament.
Part 3. The jury. Juries are used in criminal cases and in some civil actions, notably actions for libel. They are also used in some coroner inquests. The role of the jury is to use common sense to decide if the verdict should be for or against the accused. Members of a jury, called jurors, normally have no knowledge of the law and follow the explanations given to them by the judge. Anyone whose name appears on the electoral register and who is between the ages of 18 and 70 is eligible for jury service. Judges, magistrates, barristers, and solicitors are not eligible for jury service, nor are priests, people who are on bail, and people suffering from mental illness. People who are excused from jury service include members of the armed forces, members of parliament, and doctors. Potential jurors can be challenged if one or the parties to the case thinks they are or may be biased.
Listening to jury trials. In most common law jurisdictions, the jury is responsible for finding the facts of the case, while the judge determines the law. These peers of the accused are responsible for listening to a dispute, evaluating the evidence presented, deciding on the facts, and making a decision in accordance with the rules of law and their jury instructions. Typically, the jury only judges guilty or a verdict of not guilty, but the actual penalty is set by the judge. In France, and in some countries organized in the same fashion, the jury and several professional judges sit together to determine guilt first. Then, if guilt is determined, they decide the appropriate penalty. Some jurisdictions with jury trials allow the defendant to waive their right to a jury trial, thus leading to a bench trial. Jury trials tend to occur only when a crime is considered serious. In some jurisdictions, such as France and Brazil, jury trials are reserved and compulsory for the most severe crimes and are also available for civil cases. In Brazil, for example, trials by jury are applied in cases of first and second degree murders, even if only attempted. In other countries, such as the United Kingdom, jury trials are only available for criminal cases and very specific civil cases: defamation, malicious prosecution, civil fraud, and false imprisonment. In the United States, jury trials are available when the sentence exceeds 5 years, and optional for crimes for which the maximum sentence exceeds 2 years, but less than 5 years. However, the right to a jury may be waived if both the prosecution and defense agree. Because jury trials tend to be high profile in the United States, the general public tends to overestimate the frequency of them. Approximately 150,000 jury trials are conducted in the state courts in the U.S., and an additional 5,000 jury trials are conducted in federal courts. 2/3 of jury trials are criminal trials, while 1/3 of civil and other, e.g., family, juvenile, municipal ordinance, or traffic. Nevertheless, the vast majority of cases are in fact settled by plea bargains, which removes the need for a jury trial.